In Hedley Byrne and Heller in 1964, the House of Lords outlined the Hedley Byrne Principle. If you're not familiar with the principle, please watch this video. The link to it is also in the description. Now, if you are familiar with the principle, you will know that it outlined 4 requirements which need to be met in order for a claimant to recover damages for injury or damage suffered as a result of negligently passed on information or advice. Those requirements are as follows. 1, it needs to be demonstrated that a special relationship was established between the defendant and the claimant. 2, it needs to be demonstrated that the defendant voluntarily assumed responsibility towards the claimant. And thirdly, the court needs to see that the claimant relied on that information or advice. And then lastly, the court needs to be convinced that it was reasonable for the claimant to have relied on that information or advice. The first 2 requirements of the principle have been explored in previous videos. Follow the links in the description to watch them. In this video, we'll focus on the last 2 requirements of the Hedley Byrne Principle. They are, did the claimant rely on the information or advice given to them by the defendant? And was it reasonable for the claimant to rely on this information or advice? Hi, I'm Denise and you're watching Law with Denise. Now, our first question, did the claimant rely on the information or advice that was given to them? This may seem like an easy question with an obvious answer, but it is worth being clear on what the court is asking and what they are actually looking for as an answer. The court is looking for evidence that the claimant has relied on specific advice or information which was given to them negligently and which has caused them harm or damage. So it is not enough for the claimant to simply say that they thought or they think that the information or advice given to them caused them some harm. Or it is not enough for the claimant to just say generally, oh, I didn't think that that information that was given to me by the solicitor was not good enough, and I think that is the reason why I lost a certain amount of money. No, the court will want evidence that the claimant relied on very specific pieces of information or a specific piece of information or advice. For example, in a previous video, we looked at the case of Esso Petroleum Limited and Mardon. In that case, the claimant did not say, oh, I just thought that Esso Petroleum should have given me better advice, and now I can see that I've lost some money. No, the claimant was able to demonstrate that Esso Petroleum provided them with specific information or advice which they relied on. To be specific, Esso Petroleum had told the claimant that if he leased a particular petrol station, he would have been able to sell 200,000 gallons of petrol in 12 months. But in reality, after leasing the petrol station, the claimant was only able to sell 78,000 gallons of petrol in 15 months. So that advice or information that the claimant relied on was very specific, very clear. And that is what the court is looking for when they ask the question. Did the claimant rely on the information or advice given? They're looking for evidence that the claimant relied on clear, specific pieces of information or advice, or a clear, specific piece of information or advice. Now, our second question. Was it reasonable for the claimant to rely on that information or advice? Well, it needs to be demonstrated that it was reasonable for them to have relied on the information or advice. And how does the court determine that? Well, the court will look at the facts of the case, they will look at the circumstances, they will look at the relationship between the 2 parties and the transactions between them and determine if it was reasonable. In some cases, this question can become very interesting when the claimant has been provided with information for one purpose, but they use that information for another purpose and then suffer injury and bring a case to court. If the court is convinced that the information that the claimant was given for a purpose different to that which they used it for, the court will say it was not reasonable for you to have relied on this information. Now, what do we mean by that? Let's have a look at Caparo Industries PLC and Dickman 1990 in order to understand this a little bit more. In this case, the defendant provided an auditor's report to the claimant. The auditor's report was not provided for the purpose which the claimant used it for. The claimants used the reports to determine that they would invest in another company, and unfortunately, they suffered losses after investing in that company. They then argued that it was the defendant's fault because the defendants had provided them with the information that they relied on in order to make the investment. But the court said no, the information was not given for that purpose. The purpose that you used it for was to determine whether or not you would invest in another company, and that is not why the defendant gave you that information. So it was not reasonable for you to have relied on it. Similarly, in Riemann and Department of Transport 1997, the claimant was unsuccessful. Why? Well, a surveyor who was working for the Department of Transport had issued a certificate of seaworthiness for his boat. But it turns out that that certificate was actually invalid. It should have never been issued. And he found this out when he was trying to use his boat for commercial purposes. Now, because the certificate was invalid, he could not use his boat for commercial purposes. So he sued the Department of Transport. But the court said his reliance on the information or advice given, being the certificate of seaworthiness by the surveyor, was not reasonable in this context because the certificate was not issued for commercial purposes. In other words, when the certificate was issued, it was not issued for the purpose of the claimant using the boat for commercial purposes. It was actually issued simply for safety purposes. So the court said it was not reasonable for him to have relied on the information or advice for the purpose that he, the claimant, was trying to rely on it for, which was for commercial purposes. However, in Law Society and KPMG Peat Marwick 2000, the courts took a different approach. In this case, the defendants were accountants who had been asked to provide annual reports by a firm of solicitors. They did this, but what they did not do was they did not point out that they had noticed that a senior partner had been defrauding hundreds of clients. When this came to light, the Law Society had to pay compensation to those who had been defrauded. The Law Society sued the accountants. The accountants argued that they were asked to prepare annual reports, not to draw attention to defrauding. But this argument was not bought in the courts. What the courts did was they looked at the circumstances surrounding the case and they applied the Caparo three-stage test. When they did this, they decided that it was reasonably foreseeable that if the accountants did not draw attention to the defrauding, the Law Society would have suffered losses. And they said it was fair, just, and reasonable to impose a duty of care on the accountants in this case. Thank you for watching. I hope that was useful. And until next time, please remember to like, share, and subscribe. Bye-bye.